noted by this Honourable Court, it subsequently became apparent from cross-examination that the authenticity of the viral footage had not been established, and the laptop on which the original gearhouse footage had been captured had been stolen. Due to time constraints and limited resources available when these written heads of argument were compiled, the final details of this evidence led in chief, cross-examination and re-examination accepted as exhibits by this Honourable Court will be highlighted in greater detail during oral argument. So if we turn, Your Worship, to the exhibits as read with the evidence, Your Worship is aware of the A series of exhibits that details the scene of the celebration, after the celebration, and shows exactly, Your Worship, where the stage had been set up, what it comprised of, and the structures that were on site at the time. And this will be the basis, Your Worship, of the argument that it would be impossible, and at the very least highly improbable and highly unlikely, but we say impossible, for the spent cartridge to have been found where it was found if it had been fired at the celebration in the circumstances depicted in the video footage that the court has seen. Notably, Your Worship, and you will hear it through the heads of argument, no eyewitness was called, no person who attended the scene who feared for their life or feared that they'd shoot was called. If one takes the example, Your Worship, and that will be the argument, if someone took out a firearm now and started shooting before this Honourable Court, everybody would duck for cover. You do not, with respect, see that on the video at any particular stage, Your Worship, which would go against the state having proved sufficient evidence to put the accused on his defence, or put different in terms of 174 having been given a reasonable opportunity to do so, as not adduced evidence to satisfy this Honourable Court that a court acting reasonably could convict. The clearest indication of that, Your Worship, ironically, because of the way that I'm going to address, Your Worship, will appear from Exhibit A3, Photo 8, Your Worship, where the witness points out precisely where she found the spent cartridge, which, if one has regard to Exhibit A being the photograph of the stage, Your Worship, is impossible. Your Worship, one can also have regard to the further cross-examination of the witnesses called by the state and the concessions that they made. But at the end of the day, Your Worship, there is no person that has come before this Honourable Court to say, I attended that event, I feared for my life, I'm an eyewitness, there were shots fired, the following damage has been caused. Had a bullet struck me, it would have caused damage. Had a real firearm been fired in my presence, there would have been damages and injuries, or there was a very reasonable chance of this occurring. This is not, with respect, occurred here. This is borne out, Your Worship, by all of the evidence before this Honourable Court, and will be the basis of the argument in support of the discharge of accused number 1. So if we turn then, Your Worship, to the submissions, we say at the end of the state's case it became apparent inter alia that, firstly, not one of the many eyewitnesses to the celebration complained of any firearm being discharged. Secondly, not one of the many eyewitnesses to the celebration complained of any fear or danger due to a firearm being discharged. Thirdly, not one of the many eyewitnesses to the celebration had run for cover during the celebration in fear for their life or property. Fourthly, in fact, and most startlingly, not one attendee from the many people who had attended the celebration was called to testify as an eyewitness. Fifthly, additionally, there had been 5 SAPS VIP Protection Services members on the stage at the celebration in the stadium, and not one of them had seen or complained of any firearm being discharged. Sixthly, these 5 SAPS VIP Protection Services members had been traced and had made statements, but none of them had mentioned anything untoward having happened at the celebration at the stadium. Seventhly, the place where the spent cartridge had been found would have been beneath structures that had been there at the time of the celebration, which made it impossible for it to have been fired from a firearm during the celebration, unless they had been penetrated and damaged, and they had not. Eighthly, it was not possible to say when the spent cartridge had been placed there. Ninthly, it was not possible for the spent cartridge to have been ejected from the firearm on the stage at the celebration and land where it was found. And tenthly, there was no touch, DNA traces or fingerprints to link accused one to the suspected firearm or the spent cartridge. So what we are saying, Your Worship, is that at this stage it would appear that the state's case is not improbable but absolutely impossible, and there is no witness that came before Your Worship and said, standing on the stage, when I fire a firearm of any caliber and it's ejected and the spent cartridge is ejected to land in the vicinity of where this spent cartridge was found. It's just not possible. Secondly, Your Worship, there is no damage whatsoever to anything, as is going to become more clear and more apparent from the heads of argument as I proceed. Paragraph 8. The clearest indication of the deficiencies in the state's case were evident from the testimony of the investigating officer, Colonel Swartboy, who had fully investigated every aspect of this matter, been in charge of the investigation, deposed to 23 statements, and testified in chief inter alia that. And we're going to detail, Your Worship, of his evidence, because he in essence summed up the entire case for the state. Firstly, he had been assigned to investigate the alleged shooting at the celebration. He had requested permission to interview employees and staff on duty at the time of the celebration. The purpose of the interviews was to establish whether they knew about the incident and to gather information about the incident. The scene had been, and we use his term, Your Worship, we quote him, reconstructed by Sergeant Becker to ascertain where the spent cartridge had been picked up. He had received a copy of the viral footage that depicted accused one firing shots with what, in his own terminology, Your Worship, appeared to be a firearm. Sixthly, a CD was made of the viral video footage and was sealed in a forensic bag. Accused 1 and 2 had been identified as having been on the stage at the celebration. A search warrant was applied for and obtained to ascertain whether accused 2 had rifles in his possession that could fire that cartridge casing. Accused 2 cooperated fully and assisted throughout the process. Rifles were received in 3 batches and tested. He was not a ballistic expert but could clearly see muzzle flash when accused 1 fired as viewed on the viral video footage. Then there's a quote, Your Worship. One can see where the shots are being fired on the side of the stage and during the reconstruction at more or less the same area where the cartridge was found, as pointed out by the witness. And finally, the recovery of the further footage was just a confirmation of the incident together with the viral footage that was circulated. Having said that, Your Worship, when he was cross-examined, he made the following concessions. First, he had not of his own accord mentioned the 5 VIP Protection Service members of the SAPS that had been on the stage at the celebration. And I pause here, Your Worship, to highlight that Your Worship even commented at that stage that Your Worship was astounded or seemed shocked at the very least to be told at that late stage that there had been 5 members of the SAPS at the celebration who had in fact deposed to statements. There was no prior mention of this, and he never mentioned of his own accord, and he referred to it as a unintentional omission, and we had many of those with respect to Your Worship. Secondly, he had seen the statements of these officers, and they had stated therein that they had not seen any shots being fired by accused 1. Thirdly, had they seen a crime being committed in their presence, they were obliged to have reported this but had not done so. Fourthly, there was no connection by means of DNA or fingerprints between accused 1 and the suspected firearm. Fifthly, there was no connection by means of DNA or fingerprints between accused 1 and the spent cartridge. Sixthly, he had not searched accused 1's home or workplace for any such firearm. Seventhly, no powder residue tests were conducted on the suspected firearm. Eighthly, no eyewitnesses had complained about any conduct at the celebration. Ninthly, no eyewitness had been called to testify. Tenthly, he had not traced the photographer of the viral video footage. 11th, the chain of custody of the viral footage only began when the CD was created. He was unaware of the viral footage having been downloaded onto an external hard drive. The viral footage had never been authenticated and manipulation could not be excluded. The item that he had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. There had not been a reconstruction of the scene but merely a pointing out. So where he said earlier, Your Worship, that the scene had been reconstructed and it had been ascertained that
whoever's phone is ringing, please leave the courtroom now. Leave the courtroom.
We were on 9.15, Your Worship. There had not been a reconstruction scene. I beg your pardon, Your Worship. I wasn't.
It's the gentleman in the red shirt there. Please leave the courtroom. Your phone was ringing, sir. Your phone. Yeah. Thank you. Apologies. We proceed with 9.
I apologize, Your Worship. I wasn't following.
I also wasn't until it started doing after numerous requests.
Thank you, Your Worship. 9.15. There had not been a reconstruction of the scene but merely a pointing out. So what the point that I'm making there, Your Worship, is that
the next person, and I'm going to warn you, I will clear the court or invoke provisions of section 108 if it doesn't stop. For those who doesn't know what it means, I will proceed with contempt of court proceedings. Clear? Thank you.
we were on 9.15, Your Worship, and the distinction that I'm making there is between a reconstruction, which was explained during cross-examination, where you reconstitute the stage, the structures that were there, and you fire with a firearm to reconstruct the scene of the alleged crime. This was not the case. What he had referred to as a reconstruction was nothing other than a pointing out that in itself was inexplicable in relation to the allegations. And we say this in 9.16, he could not explain how the spent cartridge could have ended up where it was found. The cells and equipment had been thoroughly examined and no damage was found. He could not say whether a stage gun or blank gun had been used. And finally, he could not deny that a stage gun or blank gun emits muzzle flash. Then we have a summary, Your Worship. We respectfully submit that accused one is entitled to a discharge at the close of the state's case in that. Firstly, the state has not led any evidence to show that accused one possessed or shot a .223 Narinka rifle and or a firearm, the make of which is unknown to the state, without holding a license, permit or authorization. Secondly, the state has not led any evidence to show that accused one unlawfully possessed ammunition, to wit a .223 Remington bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or in-transit permit or authorization to do so. Thirdly, the state has not led any evidence to show that accused one unlawfully discharged the firearm, to wit a .223 Narinka rifle and or a firearm, the make of which is unknown to the state, in a built-up area or any public area, to wit the stadium. Fourthly, the state has not led any evidence to show that accused one unlawfully failed to take reasonable precautions to avoid danger to personal property, and that accused one had control of a loaded firearm, to wit a .223 Narinka rifle and or a firearm, the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the celebration. And fifthly, the state has not led any evidence to show that accused one recklessly endangered a personal property, and that accused one unlawfully discharged or handled a firearm, to wit a .223 Narinka rifle and or a firearm, the make of which is unknown to the state, in the manner likely to injure and endanger the safety or property of the general public attending the celebration. Residents of Ntantani and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the celebration. The residents of Ntantani and Gear House employees. And we say, most significantly, accused one is not required to give evidence to supplement the state's case. Now pause to explain here, Your Worship. What the state was required to do, Your Worship, in order to put forward a case for the accused to answer would be to reconstruct the scene, have a ballistics expert fire, or anybody fire shots at that reconstructed scene to see where the spent cartridges would land, what the range would be, and what damage could potentially have been caused. We're totally unaware of that. Alternatively, and as a second option, but I believe that it should have jointly been done, Your Worship, is the state ought to have called an eyewitness who said, I was there, I saw live shots being fired, I was damn scared, I had to jump for cover, otherwise I would have been shot. The bullet missed me by 1 meter, 2 meters, whatever the situation is. There's no such live testimony or reconstructed testimony, Your Worship, to substantiate the allegations against the accused. We then turn to the relevant legal principles of Section 174 of the Criminal Procedure Act 51 of 1977 and say that this provision provides as follows. If, at the close of the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offence referred to in the charge or any offence of which he may be convicted on the charge, it may return a verdict of not guilty. The procedure enacted in Section 174 of the Criminal Procedure Act is nothing new, and both the predecessors of the current Criminal Procedure Act contain similar provisions. It is trite law that the words no evidence do not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. And that's the test, Your Worship. And that's why we submit that there ought to have been an eyewitness or reconstruction to illustrate and to substantiate the allegations against the accused. Whether or not to refuse or grant a discharge at this stage of the trial entails the exercise of a discretion by the trial court, it may grant it or it may refuse to discharge the accused, thereby placing him on his defence. The manner in which this discretion by the trial court must be exercised has always been contentious, as is evident from a number of decisions. The entire history of the jurisprudence pertaining to this section was referred to by Traversa DJP in State v. Dewani, 2015 JOL 32655, WCC, the Western Cape High Court, which summarized the advent and application of the interpretation of Section 174 in a constitutional dispensation. In the matter of State v. Schupping and others, Himstra CJ reviewed the case law history of discharge applications and formulated the test as follows. At the close of the state's case, when discharge is considered, the first question is, 1. Is there evidence on which a reasonable man might convict? If not, 2. Is there a reasonable possibility that the defence evidence might supplement the state's case? If the answer to either is yes, there should be no discharge and the accused should be placed on his defence. However, the second leg of the test did not always find favour. In the matter of State v. Puravatu and others, Dutoy AJ criticised the approach followed in State v. Schupping and stated as follows. The presumption in favour of innocence, the fact that the onus rests on the state as well as the dictates of justice in the discretion under Section 174 in favour of the accused person where the state case is virtually or basically non-existent. Strengthening or supplementation of a non-existent state case is a physical impossibility. Since the inception of our constitutional order, conflicting views have arisen as to whether or not the Constitution has changed the test to be applied by court in an application in terms of Section 174. In the case of State v. Matabula and others, 1997, Volume 1 of the South African Criminal Law Reports, page 10, the decision of what was then the Witwatersrand Local Division, Clarkson J. held that exercising a discretion in favour of the state under the circumstances of this case in terms of Section 174 would, in my view, deny the accused his right to a fair trial. To my mind, the spirit, purport and objects of Chapter 3 of our Constitution can lead to neither conclusion but that the concept of a fair trial in the circumstances means that one can justify and fairly say to the state, you had your chance to prove the accused's guilt. You failed to prove a prima facie case against the accused. You cannot now seek the accused or the co-accused assistance to do what you could not do. The latter view was both followed and criticised in a number of subsequent cases. It was followed in State v. ALJAMA and another 1998, Volume 2, South African Criminal Law Reports, page 237, a decision of the Natal Provincial Division. And criticised and not followed in State v. Hudson and others, 1998, Volume 2, South African Criminal Law Reports, page 359, decision of the Ntuli Local Division, and State v. Makufani, 1998, 1, South African Criminal Law Reports, page 603, decision of the Transvaal Provincial Division. Further support for the viewpoint that the Constitution did impact on the applicable test in Section 174 applications can be found in the case of State versus Ndlangandamandla and another 1999 Volume 1 of the South African Criminal Law Reports, page 391, decision of the Ntuli Local Division, where Willis J., as he then was, held as follows. It seems to me that the provisions of Section 35(3)(h) of our Constitution with regard to the presumption of innocence, the right to silence, and the right not to testify have had these three practical consequences impacting upon Section 174 of the Criminal Procedure Act. The court has a duty mera motu to raise the issue of the possibility of a discharge at the close of the case for the prosecution, where it appears to the court that there may be no evidence that the accused committed the offence. Credibility, where it is of such poor quality that no reasonable person could possibly accept it, should be taken into account at this stage. The second leg of the test in State versus Supra should not apply. The point was finally decided by full bench of the Supreme Court of Appeal in the matter of State versus Bodyguard, 2001, Volume 2, South African Criminal Law Reports, page 703. As I said, Supreme Court of Appeal, when it held, and it's emphasized by underlining, paragraph 18, I have no doubt that an accused person, whether or not he is represented, is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. The failure to discharge an accused in those circumstances, if necessary mera motu, is in my view a breach of the rights that are guaranteed by the Constitution and will ordinarily vitiate a conviction based exclusively upon his self-incriminatory evidence. The right to be discharged at that stage of the trial does not necessarily arise, in my view, from considerations relating to the burden of proof or its concomitant, the presumption of innocence, or the right of silence or the right not to testify, but arguably from a consideration that is of more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principle that there should be reasonable and probable cause to believe that the accused is guilty of an offence before a prosecution is initiated. The reference is Beckenstrater v. Rocha and Tennyson, 1955, 1SA 129A at 135C to E. In the constitutional protection afforded to dignity and personal freedom, sections 10 and 12 seems to reinforce it. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold. That will preeminently be so, where the prosecution has exhausted the evidence and the conviction is no longer possible, except by self-incrimination. A fair trial, in my view, would at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by sections 10 and 12. It has been held that, generally speaking, questions of credibility of state witnesses do not play a large role at this stage of the trial. However, in the matter of State v. Mpeta, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it, that credibility therefore plays a limited role at this stage of the proceedings. In State v. Ndlangamandla, the court also held that credibility should be taken into account at this stage where it is of such poor quality that no reasonable person could accept it. The following quotation from that matter is apposite. In my view, the evidence of the only eyewitness called by the state, Wesley Kamanga, was of such poor quality that no reasonable person could possibly accept it. This view is shared by my two learned assessors. In the matter of State versus Agliotti, 2011, Volume 2, South African Criminal Law Reports, page 437, Gauteng, South Johannesburg, Khomo J quoted the passage of Willis J in the matter of State versus Nlangamandla, referred to above, with a proven state that it is an exercise in futility to lay down rigid rules that advance for the infinite possible factual situations that may or may not arise. Khomo J held that it is unwise to attempt to banish issues of credibility in the assessment of issues in terms of Section 174 to confine judicial discretion to musts or must not. To submit that the present legal position regarding applications in terms of Section 174 may be summarized as follows. An accused person, whether or not he is represented, is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. In deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may properly take into account the credibility of the state witnesses. Where the evidence of the state witnesses implicating the accused is of such poor quality that cannot be safely relied upon, there is accordingly no credible evidence on record upon which a court acting carefully may convict. An application for discharge should be granted. Conclusion. The evidence led by the state thus far in this matter is insufficient to place accused one upon his defense, in that there is no evidence of the authenticity of the viral video footage or the identity of what appears to be a firearm that is alleged to have been fired by accused one, on which a reasonable court acting carefully might convict. The spent cartridge cannot be tied back to the place where accused one was on the stage at the celebration. The suspected firearm cannot be linked to accused one. The spent cartridge cannot be linked to accused one. Nobody reacted in fear in response to accused one's conduct on the stage in the stadium during the celebration. None of the 5 SAPS members on the stage in the stadium during the celebration saw anything untoward on the part of accused one on the stage in the stadium during the celebration. There is no indication of any physical damage caused by any live rounds having been fired by accused one on the stage in the stadium during the celebration. The accused is consequently entitled to be acquitted at the close of the state's case. Put differently, Your Worship, there are 2 points that I wish to highlight. In regard to the submission relating to credibility and taking into account at this stage, the most indicative illustration of this, Your Worship, is when the investigating officer, Colonel Rodney Stephen Swartwell, testified in his examination in chief, Your Worship, and he uttered the following words. Firstly, what appeared to be a firearm, and secondly, that the circumstances of the case have been reconstructed, and he then went further to say, one can see where the shots are being fired on the side of the stage during the reconstruction, and more or less the same area where the cartridge was found, as pointed out by the witness. And when questioned, Your Worship, then conceded that there was no reconstruction. He merely looked at photographs of a person pointing something out that he then could not reconcile with the physical structures that were there. It was totally irreconcilable. So that's the point that we make, Your Worship, in relation to credibility and supposition playing an important role at this stage already, because he retracted, in effect, all of that evidence, Your Worship. So there ought not to be any serious regard to that statement by him when he could not substantiate it when challenged on it, and then attributed to the failure to refer in any way to the 5 SAPS protection services members who are on the stage, close protection officers in close proximity to the incidents of the night, not some far off distance or watching a video like these witnesses and like the court. And we want to make it clear, Your Worship, that to put accused one on his defense, they would require him to go testify. Yes, they're all in doubt, they don't know what it is, but I want to tell the court it was a real firearm. And that would be ridiculous to expect that to happen. That's not probable, Your Worship, it's highly improbable, and it's not the way that the presumption of innocence works. He's entitled at this stage to be presumed innocent insofar as not one particular witness can come to court and say, that which you see there and that which was fired on the stage was, in fact, a firearm. He's thus entitled, Your Worship, at this stage to a discharge. There's nothing that even would go further, even if one couldn't identify it. Let's just say the visuals were unclear, no video was taken, but if one said, and there was the following damage, there was a bullet hole through the sale of a tent, there was it lines up in the trajectory, as the court will often get in lots of cases, of where the spent cartridge was ejected from the firearm, or there's a hole that lines up with where the bullet or projectile would have left the barrel of the firearm. One cannot then say that an actual firearm was fired. It's consistent with there being no case to answer, Your Worship, in relation to the onus of proof in 174. We thus ask for the discharge of the accused number one at this stage, Your Worship. I have no further address unless Your Worship wishes to hear any particular.
Thank you. Advocate Matthews.
Thank you. If I may hand up our original heads of argument, signed by myself as well as my attorney.
Thank you. Thank you.
Thank you. Somewhat a different approach to the heads of argument. The first 7 paragraphs deal with the aspect, the legal aspect of a Section 174 application. I'm not going to repeat it because the host SC has eloquently placed the correct legal situation before the court. However, do wish to emphasize the decision of State versus Nkosi and another 2011 volume 2, the South African Criminal Law Reports, at page 482, a decision of the Supreme Court of Appeal. In this particular judgment, handed down by Madam Justice Meyer, Judge of Appeal at that time, it deals with the aspect of there being more than one accused in the witness or having been charged. I say this because even in the decision of the Baksa, there is an indication that the state is entitled to rely on the evidence of a co-accused to implicate another. In the decision of Nkosi, Madam Justice Meyer sets out that the failure to discharge a co-accused because he might be implicated by his co-accused And there is absolutely no evidence during the trial, whether being in the cross-examination or whether being what has been stated, in itself is undoubtedly denying an accused a fair trial. That decision speaks for itself. Your Worship, I'm sure if you read it, there's no need for me to emphasize the aspects of that. Your Worship, from paragraph 7, we've dealt with the 2 counts which are applicable to accused number 2. It is important to note that the cases of accused number 1 and 2 are completely different in a sense that the counts applicable to accused number 2 relate in essence to the handing over of a firearm to accused number 1 under circumstances where accused number 1 has no authority to possess it. Following from that, for some reason, it is argued by the state that accused number 2 then also places all the occupants of the stadium and the surrounding area in danger. Paragraph 8 of our heads of argument deal with the questions asked of the state in further particulars and the reply given by the state. What I've done, Your Worship, you will see, is that I've set out the questions and I've set out the replies given by the state to both count 4 and to count 6. Now, all that I wish to emphasize from these particular counts is that the state has conceded in the further particulars, as is also evident from the evidence which has been laid before the court, that there's no statement by a member of the general public to the effect that they were frightened, and secondly, that there is no statement from any person who can testify that accused number 2 in fact handed over a firearm to accused number 1. Now, this whole case as regards accused number 2 centers around this particular issue. We are not involved or don't want to get involved in credibility of any witnesses. I say so because there are no witnesses whose credibility I can attack, because there are no witnesses who have testified that accused number 2 handed a firearm to accused number 1. I deal in paragraph 10, Your Worship, with the accused's plea at the beginning of the trial. He stated, we place all the elements of the offence in dispute and specifically deny handing a firearm or ammunition to Mr. Malema at any stage. In paragraph 11, I deal with the effect of a plea in terms of section 115, because it's quite obvious that this aspect is going to get lost in the criminal trial. In this matter, Madam Justice Steyn, in the Duma case I've quoted, set out the judgment in Motlaping by the judge present at the time, Van Rijn, and it sets out the consequences of a plea in terms of section 115. It says, firstly, what is stated in the explanation is not evident. It is a disclosure of the accused's defense. Secondly, the accused exercises an election to make one and should not be coerced into making one. Thirdly, if the accused tenders a plea explanation, then it forms part of the evidential material, and the accused may be cross-examined on the contents of the explanation. D, the plea explanation cannot be used as evidential material in favor of the accused without him testifying under oath. But the next important aspect, throughout the trial, the explanation would operate in favor of the accused in that the state, and it's underlined, is obliged to disprove the defense raised in it. And Madam Justice Steyn indicates that this is a translation of the court's words at 761 to 762E, the original text of Van Rijn JP was in Afrikaans. The importance of this, Your Worship, is that from the outset of this particular case, accused number 2 has placed in dispute the fact that he ever handed a firearm or any other object, for that matter, to accused number 1. The duty was on the state and it was obliged to disprove that defense. Now, paragraph 12 and 13, 14 deals with certain aspects where indeed I deal with the aspect that there is no evidence that has been led that accused number 3 ever handed a firearm to Mr. Malema at any stage during that evening. The closest we've got in this case is Mrs. Governor, who made an assumption that because accused number 2 was on the stage, close to the vicinity of Mr. Malema after the shooting, she assumed that Mr. Malema had handed the firearm back to accused number 2. But just for the moment, presume we can assume that. That is not the offense. That is not the offense the accused is charged with. The offense is the accused is charged with handing a firearm to Mr. Malema under circumstances where Mr. Malema was not legally entitled to possess that firearm. While I'm busy with that, what evidence is there before this court that he wasn't in fact legally entitled to possess? Absolutely nothing. Now, you will see in the further particulars, and I realize Mr. Caesar only came into this case at a later stage. He seemed quite surprised about the cross-examination of the person by the name of Larry Mavundla. But if one looks at the further particulars, then the state was making the allegation from the outset that the firearm in question had been booked out to Mr. Larry Mavundla, that he was at that stadium on the night in question and was in fact in East London for some time prior to that because they had placed his cell phone. The state alleged he was on the stage. Now, no statement has been obtained from Mr. Mavundla as to what happened. Did he have his firearm on the night in question? And who did he hand it to or who did he give it to? We have the evidence of Colonel Janssen, who met Mr. Mavundla in Durban. Mr. Mavundla said, yes, the firearm you're looking for because I'm told we need to hand over our firearm. And Colonel Janssen at that stage testified that Mr. Mavundla said to him, but this firearm was not in East London on the evening in question. So this is not something that has been sucked out of somebody's thumb from the very outset of this particular case. Mavundla told Colonel Janssen, but not this was my firearm, it wasn't in East London on the night in question. Whether or not it was, of course, it's got nothing to do with us. Because even if it was here, the state has not produced any evidence to show that we handed it to Mr. Malema. The further particulars alleged the following. Accused number 2 is seen at the back of the stage carrying a rifle. Now, I want Your Worship just to search your memory, and I know it's very good. And I know Your Worship has taken in this case, I'm very happy. Whether Your Worship has any evidence that accused number 2 is seen at the back of the stage carrying a rifle. Secondly, it's alleged Mr. Snyman is the only white male on the stage before and after the shooting. Again, we search our mind, there is no such evidence. Mr. Snyman handed a rifle that belonged to tactical security to Mr. Malema. Now, where in heaven's name did the state in its further particulars get that information from? Unless there's a witness they have that they've decided not to call, who can come and tell us, I was there, I saw Mr. name on hand, the rifle to Mr. Malema. Because with the greatest of respect, we have heard absolutely no evidence to this effect. Then the state alleged in the further particular, Snowman was present when the shots were fired. There's no evidence that he was present when his shots were fired. Your Worship, why I say we don't even have to deal with aspects of credibility is because there's nothing to compare. There's no witness who can say whether it's credible or not. Because there is simply nobody who has come before this court who can substantiate the claim that Snowman handed the firearm to Mr. Malema. If indeed it is a firearm. Now, His Lordship, Mr. Justice Nugent, in the Lebaxa case, made the following remark. He said there should be reasonable and probable cause to believe that the accused is guilty of an offence before a prosecution is initiated. You cannot make assumptions and prosecute a man in the hope that something might come out during the trial which is going to implicate you. Prior to you prosecuting him, you must have prima facie evidence that he has committed the offence in question before you charge anybody. And I submit with the greatest of respect, and we will see if the state can stand up here today and honestly tell you that it has produced any witness that Snowman handed the firearm to Mr. Malema. I did glance through Mr. Caesar's argument, and I see he has quoted the old classicus of State versus Blom, dealing with the inferences one may draw from certain. Blom starts off with a very important proviso, and that is the word proven facts. If one wants to draw an inference, it can only be drawn from proven facts. It has a second leg. Those proven facts must also be the only reasonable inference that can be drawn. But at the start off is that there must be proven facts. There's no proven fact yet. As I've stated, there is one concern I have, is that we have two accused persons before court. This is a highly political case. But under the circumstances, it is quite obvious and clear that neither Mr. Sneyman is implicating Mr. Malema or Mr. Malema is implicating Mr. Sneyman. And under those circumstances, as indicated by Madam Justice Maya, Judge of Appeal, as she then was, it would be a complete, as she stated, if I may just get her wording, I don't want to misquote her. It would undoubtedly deny him a fair trial if he was not granted a discharge of that state. Thank you, ma'am.
Thank you. Advocate Caesar at this stage. I can't even see.
Thank you, Worship. I also may hand in a copy of my original heads. I have provided my learned colleagues
Thank you.
copies of the heads.
So are you saying you're ready to proceed and reply?
That's correct, Your Worship. I have drafted the heads in anticipation of what might be argued today. So I'm ready to proceed.
Okay, just a minute. Just a second, I'll be with you now. Advocate Caesar. Thank you. You may proceed.
Thank you, Worship. The state is indeed opposing the discharge of the accused is submitted that the evidence presented by the state during the trial is overwhelming against the accused. The state led the oral evidence of several witnesses. Such evidence was corroborated and substantiated with real evidence in the form of the video audio clippings depicting accused number one firing several shots in the air. A spin cartridge that was found at the scene, which later linked the firearm owned by the company of accused number two to that cartridge case in question. Accused two is also visible in the video footage where we is seen approaching accused number one after the shots were fired. This happened in a matter of split seconds. Accused one and accused two are seen walking towards each other. And thereafter, accused number two moves away from accused number one. Subsequently thereafter, accused number one is no longer in possession of the said firearm. A more detailed discussion will then follow below. The section 174 in the context of this trial have already been argued by both counsel for accused number one and accused number two. I do not wish to repeat. The principles are the same relating to what has been said in terms of section 174 discharge. In respect of this particular section, the sole discretion whether to discharge an accused is upon your worship. Where more than one accused is charged with the same offense, the court may refuse the discharge or to discharge one of them if it is in the interest of justice to do so. It's our submission that it is indeed in the interest of justice, more specifically relating to accused number two, the discharge that has been requested and the facts that have been laid before your worship, and I will substantiate my argument to your worship. On page 3, at paragraph 10 of my heads, I want to refer the court to State versus Bodyguard and another, in brackets 2, 194, in brackets 1, BCLR, 10, Sky, in brackets, the question of fundamental rights in section 174 was considered in respect of the Bill of Rights of the erstwhile Republic of Sky, where Heath J. said the following would probably give effect to the wishes of society and the purpose of the Constitution. 1, an innocent person, as far as possible, must never be convicted of a crime. I am in full agreement with that. The conviction of a guilty person must be obtained with the best possible endeavors. The right to remain silent and the satisfaction of the onus which is on the state must be satisfied as far as possible. For the rights of an accused is very important, but the rights of the community to see that justice is done is equally as important. To achieve these goals, instruments should be used in such a way that justice is done to everybody. These 6 principles are indeed very important if you look at the issues that has been raised in this particular matter. This is why I would submit that very few courts are placed in the position that Your Worship, this court has been placed with real evidence, real video footages from different places, the house, as well as the viral footage. A real firearm that was brought to this court belonging to the company of accused number 2. A real spent cartridge was brought for the court to examine, to look at it, look at the firearm, look at the footage. I'm of the view in this my submission that the court was placed in the best position to assess the evidence, to look at it and make its findings in this regard. Bishop, I summarized the evidence of all the witnesses. Mr. Otis already went through it. What is the importance from this particular summary that is the 15.2 Colonel Gamlana Mkwali, the one that opened the criminal case, that was present on the evening in question. He testified that he didn't see anything what transpired, but he was later sent this particular viral footage, of which he was of the view that in an investigation a docket must be opened and that an investigation must commence. What's also the importance of this evidence is that he said there were no prior agreements between him or any member of the party or any of the accused that assimilation of a firearm would be firing shots was discussed, and he would have to give permission in order for that to happen. I want to also refer the court to the evidence of Ms. Ntuli Mankomo. She's the one that found the specific spent cartridge. That was the cleaner that was there 2 days after the incident on the 30th of July. What's important of her evidence, usually this is just a normal, ordinary person that was performing her duties on the day in question. She's got no interest in this particular matter. She didn't even know what was that spent cartridge that she picked up. As a result, she asked Mr. Khumalo, who was working for BCM, what this was. He took a photo of the spent cartridge and then informed her that she must hand it over to her supervisor, which she did. This witness, as unsophisticated as she was extremely honest to such an extent that the evidence remained intact. What is also of importance from her evidence is the issue that was raised as to where exactly this firearm and the possibilities and impossible probabilities Usually, even if she found that spent cartridge in the air, the fact of the matter is that it was found in the area or in the stadium where these shots were fired. Where she found it, in my submission, is irrelevant. What's of importance is that coincidentally it was found on the side which one can see, on the direction where these shots were fired into. What is also of importance that the incident occurred on the 28th of July. That was in the evening. The 29th, that stadium was still, or the stage, that is the word I'm looking for, was still there on the 29th. It wasn't dismantled. They just started to dismantle it on the 29th and on the 30th. My submission is it's really irrelevant as to where this spent cartridge was found. The fact of the matter is it was found, whether it was in the air or on the other side of the stadium, on the left or the right side, it was found on the stadium. I want to take the court then secondly to page 6 on paragraph 15.7, the evidence of Colonel Johnson. It was also mentioned by counsel for accused number 2. What is of importance that when he arrived there, visiting the premises of accused number 2's business, instead of all the many firearms that were there, he was given, or 2 firearms were produced, the one that was linked to this particular incident, and then a 9mm Glock. If one look at the footages, a handgun was also, shots were also fired from a handgun, despite the fact that the accused were not charged for that offense. It cannot be coincidence that accused number 2 knew at that stage that these were the firearms. He had many firearms on their premises that the police came there to look for. And the reason this was done is my submission that accused 2 did not want to disrupt his business because he suspected that all the firearms will be taken by the police for ballistic test. As a result, that's why his attorney had to intervene so that batches could be taken, because it would have been disrupted. His business would have been disrupted if all the firearms were taken for ballistic test. The question then arises, how did he know that these were the 2 specific firearms that were the police were searching for? And coincidentally, one of their firearms tested positive to that particular scene here in Ntanzi at the Sibiya Stadium. To me, it's very important. Accused number 2 knew because he was there and he participated in what transpired on that evening in question. He knew that was the first firearms that were used by Mr. Malema, both the 9mm Glock and the 2.223 firearm that was brought to fire this court, where Mr. Gadleka linked that firearm to that spent cartridge. We have now the firearm that was used. we've got the spent cartridge. I'm going to the video footage related to this. What is also of importance is the evidence of Colonel Ndwadleka, that he was very objective in his evidence. He's an experienced colonel that testified how he managed to leak, despite the fact that the breech block of this firearm and the firing pin of this firearm was removed. In order to affect the results, he was still able to find 3 points and match that spent cartridge to the firearm that belongs to accused number 2. I've heard the cross-examination of Colonel, of counsel for the accused relating to the breech block and the firing pin and why the accused was not charged for defeating the act. That thought did cross my mind. If I had more time to peruse everything, I would have charged him for that. It's clear this was done for the sole purpose to defeat the ends of justice. You should then look at the evidence of Ashley Singh. I'm not going to go through it. Samuel Kwata and Sibiya Ngobo relating to the Gear House footage. What is important from this specific footage of the Gear House, it confirms the incident did transpire as per the viral footage. The viral footage was just taken from a different angle. From what I could do, it was taken from that particular stage where the incident occurred. But if you look at both footages, even the singing, the song that was sang at that particular time is the exact same one in both footages. The court can safely exclude that there was any tampering or that there was any amendments or alterations to the viral footage as counsel want to allude to. To do that would just amount to sheer speculation, whereas the Gear House footage have already been authenticated. We have argued this issue relating to admissibility thoroughly on the previous occasion. That was as bolted already. The only issue that the court must decide on is the relevance of those particular videos, not their authenticity. It has been stated in many case laws, which I've mentioned before. It has been confirmed by the Supreme Court of Appeal. I only want to deal with the evidence now of Colonel Rodney Stevens Swartboy, who's the investigating officer, and how he explained what unfolded during his investigation. The only issue that is really of importance from this evidence is the chain relating to the firearm that was linked, how he found the firearm at Brighton Beach from Captain Creer and brought it to the ballistic section here in Kabeja for ballistic tests to be conducted. Much has been made of the fact that he didn't disclose that the close protectors were on the scene, and usually it's not our job. Our job is to prove our case. The information was disclosed to the defense. They must do their work. It wasn't hidden from them. everything that was put to Colonel in this regard, Colonel Swartboy, it's not our work to do that. Our work is to disclose all the information, those that benefit the accused and those that are against them. Bishop, so far as his evidence is concerned, it was also said as to the close protectors didn't see, they were on the stage and so on. It is clear from this, you should want to take into consideration accused number one's own version that he fired shots on the night in question. During that incident, it's clear somebody's lying here as to whether either the close protectors were there and they didn't see or they were not there. Because in his own version contradicts exactly that point that this incident happened as described in the video footage. They were either not present or they didn't observe anything or they were deliberately untruthful. It leads to the inescapable conclusion that they were untruthful as to what transpired on the night if they were on that stage. Because accused number one confirms this incident. It did happen. He just says it's a toy firearm. We're saying it's a real firearm. It also begs the question, Your Worship, that it was raised that we didn't have any eyewitnesses and so on. If the members of the South African Police Service that were close protectors on that evening did not want to or were not prepared to come and testify, how can we expect an ordinary member of the public that were there to come here and say that is exactly what we have seen? And also take into consideration most of the people that were there were EFF supporters. So it's not strange that no witness came forward to come and testify, as been put like by my counsel for accused number two, that this case is highly political. What is important about this, it is evident from the evidence from Colonel Ntuli, from Warrant Officer Becker, Colonel Gwadleka, Colonel Nzuku, Warrant Officer Steenkamp, Captain Bota, Captain Governor and Colonel Swartboy, all of them being experienced members of the South African Police Services that uses and utilize firearms, a tool of their trade, talking about this muzzle flash they observed on the video footage. They were not prepared to commit that this was indeed a real firearm, but this was an issue that kept on being raised about the muzzle flash, which they observed during. The only reason why they couldn't commit to that because none of them are ballistic experts, but Mr. Gwadleka already confirmed that this firearm was indeed there and that firearm was used during this incident. It's linked to that cartridge. Bishop, the submissions made by accused number 1 and 2 during the cross-examination of Mr. Singh, Mr. Kwata, relating to the issues of the footages, like I've said, the Bishop can safely accept that footage is authentic. There wasn't every tampering. To do anything else would be a speculation of Bishop, insofar as the witness is concerned, that we don't have any witness, I think we brought to Your Worship the best witness ever. It's a silent witness in the form of those video footage. It's better than an actual eyewitness's evidence, which enabled the court to see what exactly transpired during the incident, as the contents thereof is unbiased, it's unemotional, it does not exaggerate, nor does it take any sides, and it doesn't have preconceived perceptions, does not have any of the fallible qualities that one can attribute to human beings. It doesn't fabricate a version. It just shows what it has recorded during the incident on the press of a button. What better witness would your worship would want in the form than that witness? It was said that the state didn't even prove its case because there was no witness, there was no this and that. Beyond reasonable doubt was described by Kenny J. in the matter of Miller versus Minister of Pensions 1942, or ER at page 372 as follows: the degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean beyond reasonable doubt or beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect justice. If the evidence is so strong against a man as to leave only a remote possibility in his favor, in which can be dismissed with a sentence, of course, it is possible, but not probable. The case is proved beyond reasonable doubt, but nothing short of that will surface. 1 + 1 = 2, plus another 1 = 3. Your worship's got the video footage, your worship's got the spent cartridge, your worship's got the actual firearm. You've observed it. And it's my submission that that is proof beyond reasonable doubt. Bishop, I submit the dictum that I've just stated is applicable and relevant to this case. It's highly improbable that the accused one fired several shots with a toy firearm or a movie gun. If the court considers that no prior discussions took place with the fellow in Khumalo. If one look at the footage, you don't need to have been an expert. You see, it looks similar to the actual firearm that was produced here in court. If you look at length and size, it was already confirmed by Mr. Kwadleka that indeed a real firearm fired that spent cartridge on the night in question. Also of importance is if one look at the actions on the video of accused number 1, he doesn't with the toy firearm fire into the crowd or fire to his gentleman that was on the stage with him. No, he takes a secluded place, moves to the right side of the stage, the far right, and he fires the shots there. Where there were either no supporters or very minimal support. If this was a toy firearm, he could have just moved it around, fired to everybody else because he was showing it off. Why didn't he do that? That's an issue the court must also consider if one look at the actions of accused number 1 on the night in question, or it was clear that that was a firearm if one look at his actions. This is why I have stated, and it's already been stated by counsel that he spoke about R versus Brown. The only reasonable inference the court can go is that indeed it was a real firearm, because this is the issue. Insofar as accused number 2 is concerned, one can clearly see from the video footage there's a discussion between him and accused number 1. Accused number 1 moves towards him, smiling, both of them. Moves towards him, give what looks to appear that he handed over the firearm, the court can draw an inference. After that, accused number 2 is seen moved away, accused number 1 is no longer in possession of the firearm. What other reasonable inference can be drawn from that? If accused number 2 was not the bodyguard of accused number 1 on that evening in question, what other purpose would he have been here in East London with accused number 1? The court is not obliged to indulge in a conjecture and to find the answer for every possible inference if one looked at this incident. You're not required to seek speculative explanation for conduct which on itself, on the face of it, is incriminating. It's submitted, Your Worship, that the evidence that was presented before court is strong and that the application for a discharge once and all can safely be dismissed in respect of both accused. That's our submission.
Thank you, Advocate Caesar. Sorry, Advocate, I just will be with you now. Is there a reply by...
Yes,
Okay, the light is blinding me, so it's impossible to look up or see anyone or even the time. Thank you. I couldn't... Yes, thank you. At least I can look. I couldn't look up at all, so... You want to reply now or after the tea adjournment, which is 11:45, then we'll take tea 10:30 to 10:45, or we can continue to 10:45 and then take it from there to 11.
I'm in Your Worship's hands.
No,
I could
no.
reply, but if there's a need for a body break, Your Worship, then perhaps it is an opportune time to take the tea adjournment, and I can reply after the tea adjournment.
I'll hear from other court officials. Advocate Caesar, you wish a break?
More instructions might also come from the accused towards the... It's a proper time.
Advocate Matthew is in agreement with the sentiments of your colleagues. Okay, just one aspect. Advocate Otis, then I'll be with you right now. We are ended off. At least now I can look up. Thank you. Ready?
Thank you, Worship. Worship, the record will reflect that your Worship made it clear in the last court appearance that if our learned friend for the state requires time to respond, is entitled to time. The Worship again asked him today whether he needs time, and he made it clear that he had compiled his head in anticipation of what might be argued. Today so he's ready to proceed. So twice the Worship clarified with him that he was ready to proceed. Unfortunately, Your Worship, he has not, in his address to Your Worship, answered the questions raised in our heads of argument. And I want to go one step further, Your Worship, and say that he seems to have confused that which he set out to prove with what he actually did succeed in proving. Thirdly, as an overreaching statement, Your Worship, his address is peppered with respect to contradictions. And I'll explain to Your Worship why I say this. I'll deal firstly, Your Worship, with his own heads of argument. And he says, Your Worship, in paragraph 3, that there's an overwhelming case against the accused. And he then proceeds, Your Worship, to say that the video and audio clippings are relied upon. The spent cartridge is the real evidence. It was found at the scene, and later in his submission linked to a firearm owned by accused 2. So he says, Your Worship, therefore the court must refuse the section 174 application. But what he goes on, Your Worship, in his written heads of argument and in his oral argument, is to then distinguish, and Your Worship will see this in 15.1, between a real firearm and what he calls an object resembling a rifle. So on his own version, Your Worship, there's a distinction to be drawn between a firearm or rifle and an object resembling a rifle. And he details, Your Worship, in great detail how the different state witnesses had the very same issue. In 15.2, Your Worship, in amplification of that, he refers to Colonel Ncube stating that a shooting or a simulation of a shooting had not been planned with him. He had heard the sound of fireworks, but having been present, did not see accused on firing shots on the date of the incident, and stated that he did not constantly observe the stage where the celebrations took place. So he puts a skittle up with respect to knock it down. So he says, this man was there, he saw everything, but he never saw a shooting. Then we moved on to Malema, who pointed out the location where the cartridge was retrieved. On his own version, as I illustrated to you, photos were taken over pointing to the location by Sergeant Ntuli. The photo album was handed in an exhibit. We agree with that, Your Worship. We move forward, Your Worship, to Jonathan Khumalo, who says he heard, and this is in 15.5, he testified that he heard a series of cracking sounds just before the EFF's event came to an end. He was unable to say whether it was gunshots or the fireworks that were displayed at the end of the event. So now we have a number of factors to take into account, and we move forward on his own summary, Your Worship, to 15.9, Warrant Officer Philip Becker, who in line 4 of 15.9 says he took it to the laboratory and swabbed it for touch DNA as well as fingerprints. He found fingerprints on the spent cartridge, but the accused were excluded. We then move across to Colonel Mandisi Magwadleke, who found 3 identifiable marks and tries to infer that that in itself should be sufficient, whereas Your Worship is well aware from the cross-examination that there's no set amount of identificatory marks and no standard test that's applied. We then Your Worship, move in his heads of argument in 1511 to Ashley Singh from Gearhouse, who he says saw for the first time on the footage that accused one fired several shots from a rifle during the celebrations. There was muzzle flash, but he conceded, and this is at the foot of page 7 at the end of 1511, the witness conceded that he's unable to dispute that it was a real firearm. I think he's saying that he was unable to dispute that it may not have been a real firearm, but that's what he says. Then you have Kwata, during the event did not see accused one firing shots from Gearhouse. Similarly, Sibusiso Nkobo, during the event did not see accused one firing shots. And we move across, Your Worship, to Yvonne Steenkamp, the warrant officer, who was unable in 15.15 to confirm that she was unable to confirm whether the firearm was a real firearm or not. We then have first reference, Your Worship, in 15.16 to a second copy of the footage, which was the testimony of Sergeant Wayne Francis. But then we move across to Captain Rian Botha, who also was unable to confirm whether the firearm was a real firearm or not. She's in his heads of argument, Your Worship. Then we have Colonel Rodney Swartboy, who he says is a repetition, and that he says the defense made much of the fact that Swartboy did not testify regarding the fact that the members of the SAPS, that was the close protectors of accused one, stated they did not see accused one firing shots on the date of the incident. So you have all the eyewitnesses not seeing any shots. Then he says in 16, it's not the, and this is what I found astounding, Your Worship, where he has regard to what the role of the state is, the prosecution. He says it's not the role of the state or the state's duty to prove the case for the defense. The information has been disclosed to the accused, is further submitted. The close protectors did not see the accused firing shots in the air during the incident. Then he comes at the end of that paragraph to the following. The inescapable conclusion should be reached that the close protectors were either not present or observed during the incident or was deliberately untruthful in this regard. So a state who's meant, in my respect for submission, to see that justice is done and put all the evidence before Your Worship, see anything that's exculpatory as putting forward the case for the defense, and that they then explains away the deficiency by saying either they weren't present or they were deliberately untruthful. But I don't know which inference you draw with any certainty from the conduct of the state in that regard with respect to Your Worship. Then, when it comes to corroboration and supporting evidence, is at page 11, paragraph 17, which is the most telling, Your Worship. I'm going to quote from our learned friend's heads of argument to Your Worship. It says, it is evident from the evidence of Colonel Nkwali, Warrant Officer Becker, Colonel Magwadleka, Colonel Mzuku, Warrant Officer Steenkamp, Captain Botha, Captain Governor, and Colonel Swartboy, all of them being experienced members of the SAPS, that use firearms as a tool of their trade, testified about the muzzle flash they observed from the video footage, albeit the fact that they did not commit to state that it was indeed a firearm that was used by the accused. Bishop, that's the state's version. They ask you, and I'm going to deal with this later, that's why I say it's peppered with contradictions and unanswered questions, Bishop, because we say you cannot disprove that it was a stage or blank firearm, and he concedes it here in paragraph 17 on his own version, Your Worship. And what we say, Your Worship, is that not one of them could say that blank or stage firearms did not emit muzzle flash. They used this muzzle flash as the test, but all of them said they can't say whether a stage or blank firearm does in fact emit muzzle flash. So then, from having said that, Your Worship, he submits in the next paragraph the probabilities are high that it was a real firearm. Bishop, that's mutually destructive of one another with respect. The expert policemen who use firearms as the tools of their trade on his own version were unable to say that you, Your Worship, must look at the video and draw the inference that they couldn't. That's the argument that he puts forward. Your Worship, in 21, I'm going to deal with this in greater detail later on because of his oral submissions. He says, Larry Mavunda was on the stage when the incident occurred and was the person who accused one handed the firearm to. I need to repeat that, Your Worship, because it goes against everything that he argued on his feet. He says, Larry Mavunda was on the stage when the incident occurred and was the person who accused one handed the firearm to. It is submitted that this is still quoting, Your Worship. It is submitted that cannot be true. The firearm question was in Johannesburg during the incident, as it would not have been possible to link it to a fired cartridge case that was discovered in the stadium 2 days after the event. This would mean that Larry Mavunda must have fired shots with a firearm that is alleged to have been in Johannesburg at the time. Your Worship, that's something that fits in with my final and my opening statement. It's a case we've never heard with respect to Your Worship. I don't know how one draws the inference that Larry Mavunda must have fired shots with the firearm that is alleged to have been in Johannesburg at the time from the facts that he uses to come to that conclusion. Because it's a conclusion, he says this would mean that Larry Mavunda must have fired shots with the firearm that is alleged to have been in Johannesburg at the time. And it must be coupled, Your Worship, with what I'm going to argue later on, that he said that Larry Mavunda ought to have been charged. Larry Mavunda isn't charged. I don't know if he expects Your Worship to find him guilty without being charged. Your Worship, in 25, he says, it's submitted that the video evidence is better than that of an eyewitness to determine what transpired during the incident, as the content thereof is unbiased, unemotional, and does not exaggerate, nor does it take sides or possess preconceived perceptions. It does not have any fallible qualities that are attributed to human beings being eyewitnesses. Saying to you, we've done better than providing you eyewitnesses, Your Worship. We're giving you footage. But then, Your Worship, you're going to see, he argues later on, you must draw inferences from the footage. You mustn't just look at it. Because the footage doesn't depict what he set out to prove. In 27, Your Worship, at the foot of 27, he says, lastly, if the firearm was indeed a toy or movie gun as alleged, it raises the question why accused one did not aim the firearm towards the supporters or the persons present on the stage, but elected to move towards the end of the stage and fired in a direction where there were minimal supporters, if any. And he argued this as well orally, Your Worship. Now, we have a charge of endangerment of people. Now you're saying that the person acted in such a way to ensure that nobody was endangered. They are self-defeating with respect, Your Worship, and mutually destructive of one another. Now, Your Worship, I've just read to you what he said about Larry Mavunda, and he refers to Larry Mavunda again in paragraph 29. He says, in addition, accused to's version that Larry Mavunda was put only at a late stage when Colonel Swapo was testifying. This version was not put to Colonel Mzuku or Captain Governor during the evidence, whereby they implicated accused to as the person to whom the firearm was handed to. Now, it was never put to them, and it was never conceded with respect to them. Don't act for accused to, Your Worship, that he was the person to whom the firearm was handed. In fact, the video was played and we saw the opposite. So I don't know what we infer or see or don't see and must infer but not see in the video. But it goes back to the reference in paragraph 28 of Rex versus Blom. Your Worship, and if one looks at Hoffman and Zephyr, they say one cannot, with respect, and I'm actually assisting my learned friend by making two submissions to it. At this stage, the onus isn't proved beyond reasonable doubt. At the end of the case, it will be. It's evidence upon which a court acting reasonably could convict, so one can infer into it reasonable doubt. But in Hoffman and Zephyr, they say one cannot, at this stage, rely on Rex versus Blom. I found an authority that ought to assist Your Worship, and it's an Imperial Marine Company versus MV Pascal, spelled Pasquale, Delegata, 2012, Volume 1 of the All South African Law Reports, page 491, decision of the Supreme Court of Appeal, with Honourable Mr. Justice Wallace is quoted as saying, it's quite an extensive quote, Your Worship, it's 3 paragraphs, but I think it sets out the case. case there very clearly. He says, whether there is a prima facie case may depend upon issues of both fact and law, as with Imperial Marine's claim for damage to the vessel allegedly suffered at Richards Bay and the claim arising from alleged SRB-induced corrosion. The starting point is the facts upon which any legal contentions are based. That's at page 500 C to D. It says, the Constitutional Court has recently pointed out deciding matters on the basis of concessions by counsel is not always satisfactory. For that latter reason, I indicate briefly why there is much to be said in deciding whether the applicant has established a prima facie case. For taking into account the facts in the opposing affidavits, an applicant does not contradict, at least where there is no reason to believe that in future proceedings the advantages of discovery of those facts are capable of being challenged. The primary reason is that in principle to do otherwise is to shut one's eyes to relevant factual material that may fatally undermine the arresting party's claim, and courts do not ordinarily disregard relevant and admissible evidence when reaching their decisions. That's at 501G to 502A. Then finally, Your Worship, further on 502 at E to 503A, Justice Wallace says, leaving that aside, two other points fall to be made about the approach to proof of a prima facie case. They are first, that where the applicant asks the court to draw factual inferences from the evidence, there must be inferences that can reasonably be drawn from it, even if they need not be the only possible inferences from the evidence. If they are tenuous or far-fetched, the onus is not discharged. Second, the drawing of inferences from the facts must be based on proven facts and not matters of speculation. Now that goes against the argument with respect. And he says in his heads of argument, Your Worship, over and above the direct evidence implicating the accused as the perpetrators of the offences, the cumulative effect of a number of probabilities pointing in the same general direction may be such as to establish the guilt of an accused beyond reasonable doubt, State versus Morgan, and then he refers to reasonable inferences, State versus Paulo, in paragraphs 31 and 32. No inference can be drawn, Your Worship, by ignoring the place where the spent cartridge was found in relation to where the State was at the time. It would not be a reasonable inference to ignore those facts, and that's why I refer to that case. It's the evidence of the State witnesses, Your Worship, that placed the cartridge there. My learned friend argues that one mustn't have regard to it, it doesn't make any sense. But in this very same oral argument, he says to Your Worship, 1 + 1 is 2, + 1 = 3, it's logical, therefore there's proof beyond reasonable doubt. But you can't, Your Worship, ignore the improbabilities of where the cartridge was found in relation to where the accused, number one, is alleged to have shot. He further, Your Worship, asks Your Worship, having made these submissions quoting his own witnesses, he says to Your Worship, it's highly improbable that accused one shot shots with a toy or movie gun. That's something, Your Worship, that's already been said by his own witnesses that they can't disprove it. And then he goes to, as I said, Your Worship, he wants to make out that he's proven what he sought to prove when he says, Colonel Ngwadleka says, a real firearm fired that spent cartridge that night. That was never the evidence with respect to Your Worship. He was incapable of saying that. That's what he may have wanted him to say, but he couldn't say it. And he asks Your Worship to then, in his oral address, draw inferences from the conduct of accused 2. Your Worship, if we've got a video where he says, I'm relying on an unbiased, perfect video, there's no need with respect to draw inferences, particularly, Your Worship, when he says that Larry Mavunda is the person in the video. So I don't know how you draw an inference from watching a video that changes Larry Mavunda to accused number 2, because beyond the realm of reality with respect. And then he asks your worship to even infer accused to his only purpose on stage was because he's the personal bodyguard of accused one. Why does that make him guilty of any offense with respect to your worship? So your worship, when I say that his argument is self-defeating, I want to highlight with respect to your worship 2 paragraphs of his heads of argument, as I alluded to earlier, that make this as clear as daylight with respect. The one paragraph, your worship, is paragraph 21, concerning Larry Mavunda that I've quoted to your worship. And what did he say to your worship when he was on his feet? He said, had I known then what I know now, but I only came into the case later, I would have charged Larry Mavunda. That's what he told your worship. Well, how do you charge Larry Mavunda when you're arguing to the court that you've proven a case against accused number 2 for that which you attribute to Larry Mavunda because you saw it on a video? It's self-defeating with respect to worship. The clearer example of all of this, your worship, is in paragraph 27. He's asking you, as I've told you, your worship, to find accused number 1 guilty of firing a firearm in a built-up area, being in possession of the firearm, the ammunition, and all the statutory offences, and endangering the people that were there, the public, the people who live in Ntsanzi, and everybody else. But he says, but he took special aim because he knew it was a firearm, your worship, to move it away from the supporters. It says, it raises the question why accused 1 did not aim the firearm towards the supporters or the persons present on the stage, but elected to move towards the end of the stage and fire in a direction where there were minimal supporters, if any. There also the objective fact that my learned friend fails to recognize in all of this is that the bullet has to, if there was a real firearm that was fired, that bullet has to land somewhere. So you've got 3 objective facts on his version. You've got a firearm, you've got a spent cartridge. That spent cartridge had to have ejected a bullet to make it a real firearm. Then pray, I'll ask your worship and my learned friend, because he hasn't answered our heads of argument, where's the damage? If one expected that there was a real firearm firing a real bullet, there's a spent cartridge to substantiate all of that. What happened? Because he says, I'm charging you with having endangered these people, that you took special aim to avoid all these people because you knew it was a firearm. That in itself is the clearest indication of a self-defeating argument. And I therefore say, with respect, your worship, that particularly in light of the submissions made by my learned friend and the duplicitous attitude, because on the one hand he says one thing, on the other hand he says something else. The witnesses did not say that which he attributes to them. I say that on the basis of that, it is clear, your worship, that there is no case for the accused to have to come and answer, because it's clear on the quotes from my learned friend's own heads of argument that the witnesses conceded that they cannot dispute that this was a blank or stage firearm. Thank you, sir.
Thank you.
Yes, and now I approach the accused.
Certainly.
I apologize. So my instruction is to add, if I may, that by now attempting to discredit the previously unheard of 5 South African Police Service, specially trained VIP Protection Services members, he's actually giving evidence to try to establish why he didn't call them, when in fact he had the onus to call them and he ought to have. And he has no basis to discredit them and put in his heads of argument with respect that either they're lying or they weren't there. Because they've given a statement, he has the document, he knows what the statement say. It was put to the investigating officer, Colonel Swartboy, what appears, and he agreed with that, which was put to him, that they hadn't seen, they were there and hadn't seen any shooting. And furthermore, had they seen shooting, they would have been obliged to have reported the matter. as is in the heads of arguments and as pointed out by my client, and my heads remains unanswered with respect to worship. Thank you.
Anything else from yourself, Advocate Matthews?
Thank you, Your Worship. I have no doubt Your Worship has correctly recorded what Lieutenant Colonel Janssen said in front of court. So I need to correct, unfortunately, my learned colleague. Lieutenant Colonel Janssen's evidence was that Clement Ntuli and Mr. Boertus were the responsible persons for all of the firearms belonging to tactical security, not accused number 2. We've heard no evidence that accused number 2 is the owner of tactical security, which is a company. I need to correct that. Then, as regards his statement about the handing over of the firearm and a 9mm at the time when Janssens was there, and trying to draw the inference that accused number 2 must have known that those 2 guns were the ones that fired on the night in question. Nothing could be further from the truth. Lieutenant Colonel Janssens testified that as he was leaving tactical security, Larry Mavunda arrived, and he who was Colonel Janssen spoke to Larry Mavunda, who said to him that I believe you are looking for all the firearms belonging to tactical security. And I have brought my firearm. In the further particulars which the state answered, it said the following. On the 6th of August 2018, firearm with serial number SPA 249 was presented to Colonel Janssen by Larry Mavunda. Accused number 2 had absolutely nothing to do with the handing over of that firearm. It was obvious from Colonel Janssen's evidence that he had met up with Larry Mavunda. What of course my learned friend is forgetting is that the police by that stage had already requested that tactical security hand over the firearms that they had in their possession, which were of more or less the same caliber. By that stage there was already an agreement that tactical security would hand over the firearm in batches to the police. In order to do this, it only makes common sense that tactical security would be calling in all these firearms from every single corner of the Republic, because they are not a company that supplies security only in the Durban area, but throughout the country. These firearms had to be called in, and that was the evidence of Colonel Janssen. That the firearms were being brought in from all corners of South Africa to be presented to the police and to be given to them. Colonel Janssen didn't take Larry's firearm, nor did he take a 9mm from Larry on the day in question. It was handed into the company and handed over to the police as we have heard the evidence of the investigating officer. Janssen was there in his capacity as the DFO of the province, so that he could look through all the registers to ensure that the company's firearms were all in order. He testified that he did that, and in fact they were. So now to attempt to draw this inference that accused number 2 knew exactly which 2 firearms to to hand over is simply not the truth. Your Worship, to say, if I'd had more time, I would have charged Larry Mabunda. I don't want to say it again. I can't believe that my learned friend is saying that. Into further particulars, before this case proceeded, 2, 3, 4 years ago, the previous prosecutor, Elna Smith, wrote the further particulars truthfully as she could, and she did the right thing. In those further particulars, she mentioned that Larry Mabunda had been issued with that firearm, that he was in East London on the night in question, and that it's alleged that his firearm was the one that had fired the cartridge case on the night in question. She made the right decision because there is no evidence to suggest that Larry Mabunda fired any shots on the night in question. And there is no evidence to suggest that he handed it to anyone. But as we have heard from the cross-examination of the investigating officer, he was asked, why didn't you take a statement from Larry Mabunda? So he didn't want to give one. But they didn't want to use Section 205 to force him to appear before a magistrate and explain the position. So, my learned friend's argument in that regard with respect has got no merit whatsoever. And then your Worship would have heard, which is so telling in this case. While he's addressing you, he says to you, the video shows, and he's about to say, accused number 1 handing the firearm to accused number 2. Then he hesitates and says, the firearm shows accused number 1 handing, and then he realizes that it doesn't show that. Then he says, we can draw the assumption that he handed to accused number 2. You know what, I can almost go as far as to say, so what if accused number 1 handed the firearm to accused number 2? That is not the charge. The charge is that it was accused number 2 who handed the firearm to accused number 1 prior to the shooting. What my learned colleague is talking about is after the shooting. If this court can say because there's an assumption that it appears that accused number 2 handed a firearm to accused back, it appears that accused number 1 handed the firearm back to accused number 2 after he had fired it. Therefore, I can draw the inference that it must be accused number 2 who handed to accused number 1 in the first place. Well, I'm afraid, Your Worship, that is not going to do. Thank you.
Thank you. Just a minute. Sorry, I'm not sure if you were still taking instructions or what is...
Maybe
good.
my client didn't understand. Maybe I should just put it to you this way. You should just clear from the evidence that when Janssen came to do the inspection at TSS, the evidence shows that by that time there had already been an arrangement that the firearms were going to be handed over to the
You indicated you want to reply at the
Just one aspect, I didn't say that I would have charged Larry Mabunda. I said I would have charged accused number 2, and not Larry Mabunda. And if I did say that, it must have been a slip of the tongue for changing that breech block and for changing the firing pin. lastly, Your Worship, the issue relating to the witnesses that uses them as the tool of the trade and so on, they are not ballistic experts, so they correctly confirmed that they were not able to say whether it was indeed a real firearm or not. The importance of the evidence here is that of Colonel Ngwadeka was already mentioned. Your Worship, with regard to other issues that was interpreted, my heads are there. Your Worship, I, like Colonel Ngwadeka correctly said, I don't feel that justifies an answer. Thank you.
Okay, that is all from anybody. Close this chapter. Okay. Of course, you don't think that it can be expected of me to simply proceed with judgment in this matter right now. I will also consult my diary, weigh the options, and then since we are, I don't know how we'll do that. We'll do it in open court, I assume. So let me just think about it. There's a lot to read. I'll give an example, and I'm not throwing anyone under the bus, but the various statements has been said. You can look in the statements, the words aren't written there. I've perused it thoroughly. Those documents were placed on this bench that day. I also have to peruse and satisfy myself with the contents of each and every document, each and every submission made by the state, Advocate Odes and Advocate Matthews. So I will look at the volume. I don't know, what is the time? I can't see. 11:30. 11:30. You don't have to. I'm not going to do it today, Advocate Caesar. That is in essence what I'm saying. I just want to come back with an indication of the time frame that I require. So for that purpose, do we stand down now at until 12 for me to indicate?
No issues.
All right. I don't have this thread. He wants me to fall down the steps by blinding me so that I can't see the steps. That's fine. All right. Thank you. Court will adjourn. Back on record. Resumption of RC 446 of 2020 then. Just to place on record the proposals made by the court to Advocate Odes with regards to accused one was that I could endeavor but cannot guarantee that I can proceed with the ruling on Friday. They have suggested a subsequent date which seems to suit all parties, and that being the 19th of October, due to the unavailability of some of the parties present today. It cannot take place Friday. Is that correct?
I confirm that.
Thank you. The matter then postponed to the 19th of October. Accused 1 and 2 on bail extended, warned 8:30. I would say Regional Court 1 for the judgment by court on that day. Thank you. Court will adjourn.
Sorry,